Hello, good afternoon. Thank you to the Union of Lawyers, to the Bar Association, and to the Chamber of Arbitrators for inviting me to participate in today's conference. Unfortunately, I could not attend in person nor live, so this presentation is pre-recorded, and I'm conscious that watching on your screen, somebody reading off their own screen is probably more effective at inducing sleep than melatonin, and therefore I will try my best to resist the temptation of looking at my notes before me. In the 20 minutes available to me, I will essentially speak about the challenges of and opportunities in deromanticizing the duty to apply the law. I'm conscious that it's a flatly provocative title. The intention is by no means intended to provoke, but simply to elicit some curiosity. In the 20 minutes available to me, therefore I will make two observations and one suggestion. The first observation is that the duty to apply the law is romantic and romantic. The second observation is that the duty to apply the law, although straightforward in appearance, is more complicated than it appears to be. That this duty entails, in fact, instances where arbitrators have not applied the law and arguably should. And based on that observation, I make a suggestion, that perhaps it is worth considering a reformulation of the duty so as to depart from a prescriptive duty to apply. And then I'll obviously nuance that suggestion by reference to some challenges of to any sort of before jumping to these two observations and that one suggestion, I should perhaps clarify for members of the audience who are less familiar with international arbitration what we mean when we refer to the duty to apply the law. We all know that party autonomy is one of the cornerstones of international arbitration, that beyond agreeing to have their dispute resolved and determined by international arbitration, parties have various choices to make, or choices that they're encouraged to make. One of the choices which they're often encouraged to make is to choose the law or legal rules or laws which are applicable to the substance of their dispute. These can be national, sub-national, state, and provincial laws. They can be non-national law, they can be international law, they can be a combination of all of the above. And there are various strategic considerations behind any such choice. The duty to apply the law is simply put the duty on arbitrators to abide by the party's designated applicable law. Now the romance, and I'll confess to you that the romance is something that occurred to me while reading a chapter contribution by ICA M.Mahayni, a very illustrious arbitrator. Her contribution was titled "The Law Applicable in Investment Treaty Arbitration," but the same statement applies to commercial arbitration, which is the end of my presentation, in a 2010 edited book. And she states, and I quote, when the applicable law has been chosen by the parties, the arbitrators have a duty to apply such law and nothing but such law. She goes on to say, it is only in the absence of a choice by the parties that the arbitrators are entitled to exercise a degree of discretion in the determination of the applicable law. Now, that second statement is outside the scope of this presentation. Indeed, when the parties have not selected an applicable law, it is on arbitrators to determine the applicable law in their stead, and there are two principal ways in which arbitral rules and statutes formulate this ability to determine the applicable law, and there is a sizable element of discretion in this, but we won't get into that. In this presentation, I'm simply talking about the duty placed on arbitrators to apply the law or legal rules or laws which are chosen by the parties as applicable to the substance of the dispute. And here, matter of fact, it says that arbitrators have a duty to apply such law and nothing but such. For me, when I read this, and the more I thought about it, it represented a certain layer of romance. On the one hand, we have the law. I think most attendees will probably be either legally educated, legally trained, legally qualified. As lawyers, we are wired to fetishize the law. Like love, it provokes a certain feeling of mystery, of excitement. It provokes understanding, misunderstanding, elusiveness. It provokes protagonism and antagonism as to what the law is and what it should be. That's one layer of romance. The other layer of romance is in speaking of the duty to apply the law and nothing but such law. For me, that almost sounds chivalrous. Like it is virtuous to apply the law. And this should be understood from how the duty to apply the law actually and legal rules applies in appears in arbitral statutes, civil procedure codes, and institutional rules, where explicitly, typically, alongside the duty somewhere at some point in the same article, arbitrators are said that they cannot act ex aequo bono or amiable compositeur unless they have been expressly authorized to do so by the parties. So the law is almost put distinctly to what equity is, despite the fact that most laws obviously integrate equity within their laws. And so before this two-pronged romance, I made an observation, that's my second observation, that actually in reality that's not necessarily as romantic as it seems, because there are instances where arbitrators simply do not apply the law. And I can think of two examples here, various examples, but let me focus on just two. Let's say you have a contract between two parties, and the parties designated an applicable law. Now, one party, after the contract has been signed, perhaps some of it has been performed, decides that it's in its interest to escape its obligations by arguing that the contract is valid or inescapable. It finds a mandatory rule in the applicable law which has that effect, to render the contract invalid and or unenforceable because of perhaps some formality or something in the applicable law which effectively has that result. What do you do if you're an arbitrator in those instances? Do you apply the terms of the party's contract, which evidently say one thing, or do you apply the terms of the rule, the mandatory rule in the applicable law, which says something else? There is a trade-off. And most authors that I have read on the issue will say that, well, there are considerations for and considerations against. You might consider that party autonomy, the party's choice of law, requires you to apply the mandatory rule, that the legitimacy of international arbitration as an institution requires you to apply the mandatory rule, that the survival of international arbitration requires you to apply the mandatory rule. Others will say, well, not necessarily. You also have to look at the party's expectations, the result of applying the mandatory rule, and the impact that this has on the party's expectations at the time. Others submit that you also have to look at how legitimate the mandatory rule actually is. Is it congruent with, for example, transnational public policy? Yet others will say, well, it really depends on the facts and circumstances of each case, on the sophistication of the parties, on their expectations when they actually selected that applicable law, that they actually understand and expect that this mandatory rule would apply. And so there are various considerations for and against, but you will find that at least a good portion of the arbitration community, at least those whom I have read, agree that there are ways to circumvent the mandatory rule, and there are justifications, in fact, to do that. That's one example. Another example is where you have, for example, again, two parties, they designated an applicable law. They concluded a contract, but the contract does not actually reflect most of their pre-contractual negotiations. And then one contracting party seeks to capitalize on the fact that the contract actually does not reflect the party's understanding of what they were agreeing. and strategically tries to invoke this to its advantage, tries to enforce a contract which does not reflect the parties' expectations of the agreement. Now, if you're an arbitrator, you have to interpret the law in accordance with the contract and in accordance with the rules of contractual interpretation which are available under the applicable law. But let's say that the applicable law excludes the possibility of using pre-contractual negotiations to add to, vary, or contradict the clear and precise terms of the law. What do you do in those instances? At least in my experience, some arbitrators are willing to overcome some of the constraints which arise from the rules of interpretation in the applicable law for the sake of fairness, reasonableness, justice. And it's not only my experience which indicates this. In fact, a survey corroborates that arbitrators do not always give the weight due to the law, to the rules of interpretation under the applicable law. It is notably a survey conducted by a Canadian professor at Queen's University, where he analyzed 73 awards, conducted 20 interviews with international arbitrators who presumably are reputable. We won't know because their identities were kept anonymous. Where he concludes that the analysis of published awards showed that arbitrators tend to follow a relatively conservative approach, regardless of the law. This approach is characterized by invocation of the subjective intention of the parties, and emphasis on reading the contractual text in its commercial context, and an inclusive approach to extrinsic evidence of the parties' intention. Now, again, here this suggests that the applicable law is not the be-all and end-all, despite the fact that arbitrators have a duty to apply the law selected by the parties, with no apparent discretion to depart from the implication of that law. They do depart from the law. Now, this may seem wrong, controversial, but when you take it in the context of international arbitration, perhaps it seems more palatable. Most arbitrators agree that arbitrators do not approach the applicable law with the same syllogistic rigor as judges do. Arbitrators are not tasked with establishing precedent. They're not tasked with harmonizing the law in their legal system. They're sitting, acting as ad hoc adjudicators to finally resolve a dispute, which in most circumstances, absent an agreement to have an appeal of a court of law, is final on the merits. And oftentimes they do this where there are various laws which are relevant: the law of the arbitration agreement, the substantive law, the law of the places of the likely places of enforcement. They do this where the parties, their counsel, the experts, other arbitrators might be from different cultures and have different legal educations. They do this in instances where the parties may have different levels of sophistication. They do this where the nature of the transaction can be just as important, the trade usages can be just as important, the terms of the contract can be just as important. And there's a multitude of considerations. International arbitration is a sui generis method of dispute resolution. And actually, I was very pleasantly surprised to note that Article 35(3) of the Chamber of Arbitrator Rules expressly imposes on arbitrators a duty to take into account international arbitration practice. And indeed, international arbitration is a beast of its own, and therefore it's understandable that perhaps arbitration practice informs more how the duty to apply the law should be understood than when that duty is read in an ether without the context of the reality of international arbitrators' interpretation and application of the law, without the context of the reality of international arbitration proceedings and the various aspects and factors which make it so unique. And so if this is right, then my suggestion is, well, perhaps we should consider reformulating the duty to apply the law. We already have an example from Rule 24C of the JAM Comprehensive Arbitration Rules and Procedures 2021, which said the arbitrator shall be guided by the legal rule that the parties have chosen. Perhaps that's more authentic and realistic of describing the authority that the applicable law can, and indeed seemingly, at least sometimes, but arguably oftentimes based on part of the study, has in practice. And we think that perhaps such a reformulation might be might help users understand what the implications of the choice in the law actually are and what their choice entails. Now, I'm conscious that I'm running out of time, so let me just present off the top of my head, not off the top of my head, but some brief considerations of my various reasons why I think perhaps we may be better off leaving the rule as it is. First of all, the first consideration is that if you were to reformulate the duty to apply the law as a duty merely to be guided by it, or a duty merely to take into account the law for legal rules that the parties have chosen, then you're almost blurring the line between a decision by law and a decision by equity. What would then the difference be between a decision in law and a decision at amiable propositeur, which then allows arbitrators to depart from the law where this would produce an unjust outcome? I think there are some important nuances between amiable proposition and the reformulation which I have presented. But it is a question, and I wish this session will allow because it will allow me to get a sense of what other attendees think. It's a question which is one thing before, should not exaggerate, but it's a question which has been on my mind for as long as I can remember, since 7 years ago when I first came across this quotation from NASDAQ. That's one consideration. The other consideration, well, do we really need to say that arbitrators merely have to take into account the applicable law? Why do we need to say that arbitrators should have discretion to disregard the applicable law when most applicable laws already contain the wiggle room necessary for judges and arbitrators to be able to quell the unfair, unreasonable, unexpected, one-sided interpretations that strict application of the law would otherwise entail. Again, I think that a skilled arbitrator would be a good comparative. This would be able to make sure that any unreasonable solution which results from the strict application of the law would be managed through plausible legal reasoning, and if at worst and at best persuasive legal reasoning. But here again, I can think of a counter argument was to say, well, regardless of how skilled the arbitrator is at ensuring that the interpretation ultimately produced capitalizes on the wiggle room within the applicable law to ensure that the interpretation does not lead to an injustice or something which defiles the parties' expectations. You still have situations which clearly lead to a conflict between, such as the one which I presented between the contract and the mandatory law. How do you get around the mandatory law in the mandatory rule in the applicable law? And would that circumvention of that mandatory rule not actually be more misleading than authentic? Wouldn't it be more authentic simply to say that, listen, we took into account this applicable law, including its mandatory rule, and because of factors X, Y, and Z, because of these other normative sources such as the contracts, such as trade customs, to the extent that the applicable law does not account for trade customs, in light of arbitration practice, it makes sense not to apply the rule under the applicable law. Again, it's an open question. So, I mean, those are two immediate challenges which I can think of, and perhaps the solution is not necessarily one of reform, but perhaps one of giving parties options. There is not necessarily a one-size-fits-all solution. arbitrators, the international arbitration community aspires for some form of universalism. But maybe the solution is simply to say that some users are participating when they designate a law, they expect that law to be applied, to actually be applied. And other less sophisticated users may agree that their choice of law is more a matter of convenience, of neutrality, even though they, the places of incorporation, their nationality, may have very, the performance of the contract may have little or nothing to do with the applicable law, beyond the fact that the applicable law is generally a reputable, reliable law to pick for any number of generalizations. And so in conclusion, bearing in mind that I'm already at 20 minutes, in conclusion, I think that there's scope for deromanticising duty to apply the law. Either that, or actually placing a footnote, simply put, by the duty to apply the law, to say that the duty to apply the law or the legal rules which the parties have agreed contains or elicits a very international arbitration practice specific understanding, which may not be properly understood without knowledge of and arguably expertise in international arbitration, so as to make sure that users are not misled when they by that duty when they ordinarily read. Thank you very much for your time. I'm sorry that this session is pre-recorded. It's I hope I've tried to maintain your interest. Please do feel free to get in touch either via LinkedIn or email. I welcome any suggestion, observation, or any criticism if you have, any feedback you have on this presentation. And I do hope that we have a chance to discuss it further collectively as an institution, as a community. Thank you very much for your time, and thank you very much again for your attention. Have a great afternoon.